Oh yes, oh yes, oh yes, the Honorable Court of Appeals of Tennessee is in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning.
Good morning.
And welcome to the Court of Appeals. First of all, I want to thank the clerk's office and our security, the trooper, as well as maintenance for getting the door fixed so that we can get in and out of the court today. It's always a good thing. We had a little difficulty yesterday. It could have been user error since I was, in fact, the person trying to get in and out the door. So who knows? But, and we also note that Ms. Dempsey has an assistant with her today, I see, in training. Well, we're pleased to have you. Welcome to the Court of Appeals. We appreciate you being here today. Going to run over the ground rules. They're very basic ground rules. I'm sure both of you being experienced practitioners understand them. Each side gets 15 minutes to make its oral argument. If you are the appellant and you wish to reserve any rebuttal time, please request that from the court after you come up and you've introduced yourself, and you may reserve up to 5 minutes of rebuttal time. Obviously, you don't have to reserve any. Our lighting system is very straightforward, or at least it is to us because we've seen it a bunch of times, but we have 3 lights, green, yellow, and red. So long as the light is green, you have plenty of time. When the light turns yellow, you're running out of time, and when the light turns red, you are out of time, and we ask that you please respect those time constraints as well. I will tell you that this argument is being live streamed, so if that makes any difference, please be aware of that. And I also want to introduce our panel for today. We have Judge Kenny Armstrong from Memphis, Judge Carma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Miss Angie, anything we need to take up before we get started?
No, Your Honor.
You may call the first case, please.
Ida Steinberg versus Renea Steinberg et al.
I think you flipped on us.
We got the wrong ones in there.
Well, that's okay. That's
Sure,
right.
we can move.
It's okay, but you had me confused when I saw you get up.
Yes, sir. Good morning.
Good morning.
My name is Scott Vincent, and I represent Ms. Ida Steinberg as the personal representative of the estate of Mr. Lewis Polk. Rather than read to your honors, I would like to reserve approximately 10 minutes of my time for rebuttal. Is that too much?
We only let you reserve up to 5.
All right, let's just do 5 then.
Okay, great.
May it please the court, counsel. Again, I represent Ms. Ida Steinberg. This is a very narrow issue for appeal. I brought the record with me, and it's quite voluminous. It's an estate that was opened in 2016 following the death of Mr. Louis Polk Steinberg. He died in 2016. The estate was opened within a couple of months. Ms. Ida Steinberg is one of Mr. Steinberg's daughters, and she acts as personal representative to this day. The case began in 2016, as I stated, and it plugged along until about 2018, whenever a couple, the appellees actually, a couple more of Mr. Steinberg's daughters filed a will contest. About a month after that, the parties agreed to a mediated settlement agreement to resolve some issues. And then, excuse me, as stated in the briefs of both the appellant and the appellees, things do as they do in some cases, and they begin to go sideways, which opened up a pretty generous amount of litigation that has continued for quite some time, and much of that is what gave rise to 2 orders that are the subject of this appeal. They are both orders granting attorney's fees. One based on a rule, it's a statute that follows Rule 12.026. It's 20-12-119, which the appellees have called the loser pays statute. There's also a granting of attorney's fees based on, this is alternatively with the 20-12-119, under Rule 11. That is directly against Ms. Steinberg as a personal representative. There was another order that was entered following a motion to enforce a mediated settlement agreement. An order was entered that subsequently led to an award of attorney's fees under the motion to enforce a settlement agreement. And that's what we're here about today. Although there was a substantial amount of filings and the record's large, we're really here about 2 orders. So let me give a little background on that. During the course of litigation, there were a number of motions filed that related to the personal representative and the appellees disagreeing about the manner and the timing of which certain personal property would be distributed, which was the subject of the overall settlement of the parties. During some of the filings in the course of that, attorneys for appellant had filed a response to a motion that included as a counter motion a motion for Rule 11 sanctions. That motion was subsequently denied, and it was met with a couple of challenges. One of which was that the counter motion for Rule 11 sanctions did not comply with the 21-day Tennessee safe harbor provision. Tennessee's got one of those, as we all know. Other states don't have one. Mississippi doesn't have a safe harbor provision. You just have a Rule 11 motion, you file it, and then you go down and argue about it. Tennessee has a 21-day rule. So in response to the counter motion, though, the appellees filed a Rule 12.026 motion to dismiss, which generally would require that a pleading and a claim be submitted in order to file a Rule 12 motion to have it dismissed. But the appellees had proceeded in that manner, rather than filing a simple response to the motion, or the Rule 11 motion, and saying it didn't comply with the safe harbor rule. They filed a motion to dismiss it. And they made their request for attorney's fees based on 20-12-119, not Rule 11. That was their basis for the attorney's fees. That motion was, the motion to dismiss was granted. And rather than read from the briefing, it's all. Yes, sir.
Let me pose
Yes,
a question for you. The 20-12-119, and I hope I've got the number right. Is that even an issue for us today?
The only reason why it's an issue is because the judge relied upon it in the order.
Well, the statute's pretty straightforward about when attorney's fees can be imposed under that statute. And that's at the end of the litigation, if I understand the statute correctly. Is that accurate?
Well, and that sort of brings up another issue and why we're here. And I think I know where Your Honor is going as to whether or not that was a final ruling such that it's appealable. And the reason why I would submit that...
I really I don't even know. In a state case, it's always a moving target about when something's appealable.
Yeah.
But in this instance, the litigation is still ongoing, isn't it?
It is ongoing. The estate's almost ready to close. This is one of the things that's tying it up. But again, I've struggled with this. I struggled whenever I wrote the brief as to how to address this particular issue. I've never seen a Rule 12 motion filed against a motion, and I've never seen that statute used to award attorney's fees whenever it came to resolving a Rule 11 motion. But the judge did put that statute in her order awarding attorney's fees. Alternatively, she put in Rule 11. The problem with the Rule 11 motion is that, again, and this is stated in the briefs, it's in the Lambert case that we cited, the order itself has to state the basis for the attorney's fees, what the conduct was that gave rise to it. The conduct is specifically articulated in Rule 11.02. The order itself doesn't make any mention of what the conduct was or what the basis of it is. It just said that for successfully defending the Rule 11 motion, the appellees are entitled to attorney's fees.
And let me make sure I have the chronology correct there. It was your client who initially filed the Rule 11. Is that right? Is that
Yes,
right? And it wasn't, the safe harbor provision was not complied with. Is that correct?
That's accurate. And we're not appealing any substantive issue on that.
So in response to your initial Rule 11, the appellees filed a motion to dismiss the Rule 11 and requested attorney's fees.
Under the statute?
Under Rule 11. Under the statute and Rule 11?
No, they never requested attorney's fees under Rule 11.
Okay.
They requested under the statute that bootstraps onto the Rule 12 motion, which is why we're talking about that still.
But yet the trial court awarded, at least alternatively, attorney's fees under Rule 11?
They did. Under the original order that granted the motion to dismiss, the motion for, the Rule 11 motion was denied for failure to comply with the safe harbor rule. And the judge reserved the issue of attorney's fees under 20-12-119. Then subsequently, and she reserved the issue for a future hearing on the attorney's fees. Subsequently, there was a hearing on attorney's fees. Then for the first time in the order that granted the attorney's fees, and those are the two orders that we're appealing, the July 28th and July 27th of 2020 orders that actually granted them, was the first time Rule 11 was mentioned as an alternative. Again, it was 11.03A1, which is the normal rule you would look at, and the way I read it, even though the judge doesn't articulate it this way, is that the prevailing party would get attorney's fees for a Rule 11, winning on Rule 11. That's not what the order says. It just says for successfully defending. But if you look at that rule and you look at Lambert, which is pretty much a similar case that came from Your Honor's Court that explained how that rule works, you have to, in an order as a judge, explain the basis and the conduct for the Rule 11 fees, which was not done in the order. It just wasn't.
I'm sorry, what
Yes,
is the difference between prevailing on a Rule 11 motion and successfully defending against a Rule 11 motion?
Semantically, perhaps none, but practically from the order's perspective, the order has to again specifically articulate the basis for the award and the conduct would be from Rule 11.02. The order doesn't have that. If you look at the Lambert case, which we've cited, it specifically says, and I'll quote from the case, a violation of Rule 11.02 is sanctionable if the party, attorney, or law firm to be sanctioned does not withdraw or correct the offending filing document or representation after receiving notice and a reasonable opportunity to respond. Although the imposition of Rule 11 sanctions is reviewed for an abuse of discretion, a court imposing sanctions must describe the conduct it determines violated Rule 11.02 and explain the basis for any sanctions it imposes. This directive is mandatory. Failure to describe the conduct determined to constitute a violation or to explain the basis for the sanction imposed is grounds for reversal. That did not happen in this case. It's not in the order. It's honestly that simple.
What about the settlement agreement?
Settlement agreement, again, in the settlement agreement itself, the motion to enforce the settlement agreement, the basis for the request for attorney's fees was 20-12-119. I have no idea where that came from because that definitely does not apply to this, but that was the basis. The judge reserved the issue for future hearing. The judge then held the hearing and issued an order granting attorney's fees and relied upon Lever versus McBride. That's a 1974 case that says that if someone who is not the personal representative retains a lawyer and has a claim for attorney's fees, then that can be granted against the state if it inures to the benefit of the entire estate. There is no finding that ever happened. That's not the case in a will contest. And
Is that the settlement agreement analysis though?
well, the settlement agreement itself doesn't have anything in it that would address attorney's fees. Appellees have actually pointed to cases in their brief that addresses the ability of, and they go through several cases, and we've distinguished them in the briefing, but whenever there's a settlement agreement when the judge can award attorney's fees, they actually cite cases that suggest that in order to do that, you have to have a burden shifting analysis test where the judge is to be satisfied that the burden for the requesting party, they've met their burden to shift that burden over to the estate to show how the award of attorney's fees does not inure to the benefit of the estate. That argument was never made at the trial court, and the judge certainly did not put anything in the order. It was literally a one sentence, I can award this under Lever versus McBride.
Okay, you got your rebuttal time, and we'll hear from you in rebuttal.
Yes, sir, thank you. Sorry, I've got a major mess.
No problem.
Good morning.
Good morning.
My name is Jana Lamana. I am here for the appellees, Kimberly Steinberg, Judy Franklin, and Renee Steinberg. Mr. Aubrey Brown, who represents Kimberly Steinberg, is not before us today. However, I'm arguing our response and an argument this morning for all counsel involved. Okay, if I may begin. Your Honors, I would like to clarify for you the actual language that is in the orders at issue. That's the first thing I'd like to do this morning. I mean, you've already heard from the appellant about the long history of litigation that we've had in this case. The case is still ongoing. Right now, we're waiting on the ruling from the trial court as to whether or not to remove Ms. Ida Steinberg as the personal representative of this estate. Hopefully, though, we are getting close to a resolution of all the issues. So,
Well,
I think
since the case is still ongoing, is Section 2012-119 even applicable here?
I don't think that section is applicable to the case that we have here this morning, and I'm going to tell you why.
Okay, well, I agree it's not, but,
Okay, yeah.
I mean, the language is pretty straightforward.
I don't necessarily think it's applicable. In April 16th of 2019, as you know, the appellant filed a counter motion for Rule 11 sanctions, and the title Rule 11 sanctions is in the heading that they asked for it. They want to sanction both Attorney Brown and Attorney LaManna for various issues that the appellant alleged occurred. No 21-day harbor letter was provided with that. So in response, a motion to dismiss was filed, and the motion asked, and it went through a long litany of why the case should be dismissed under Rule 11. Went through the reported case of Brown versus Shapley and various other cases that provided that the trial court shall dismiss a case when the Rule 21-day or the 21-day provisions are not complied with. There was a hearing. We filed on April the 26th. We filed a motion to dismiss specifically quoting Rule 11.03 and asked that the court dismiss the appeal for violating the safe harbor provision. Now, additionally, we asked the court to dismiss it under Rule 12, and that's when we asked the court to, basically provide us fees for prevailing on a motion for, on a Rule 11 sanction, because we prevailed on the motion for Rule 11 sanctions, or we successfully defended it, and for TCA 20-12-119, and for any other relief as justice so required. Okay, so that was the basis of that motion, and then on June the 6th, we filed a second motion asking that this court enforce the mediated settlement agreement. And we asked the court to grant us attorney fees for any and all further relief that was required. Now, both of those matters were subsequently heard on various dates in 2019. And on November 5th, the court entered its order granting us attorney's fees for the enforcing the mediated settlement agreement. And Your Honor, I believe that the court had the basis to do that based upon the fact that our actions in enforcing a settlement agreement based upon to assign royalties did inure to the benefit of the state. The court had a hearing on the fees, and the court awarded our fees based upon my belief that the court thought that we had, that the actions of the appellees had inured to the benefit of the state. But moving on to the November.
Is it your belief that's what the court did?
It is my belief that is what the court did. The court had heard, the record's long, the record's complete. We had expert testimony that had been presented by a woman attorney in Nashville on the issue of assignability of royalty rights. We were stuck. We had to file that motion to enforce to keep this estate moving along. We were successful. These royalty rights have now been almost successfully transferred to the beneficiaries after a second filing of a petition for contempt that we had to file. Okay.
So, how do we know that's what the court did?
You don't. Okay, you don't. However, I don't think that that is necessarily required in this instant. I think that the court had the fact that the record was before the court, and the court had granted fees, knowing full well from the long history of this litigation what had been done and what had been benefited to this court. There's nowhere that it says that has to be, I don't think that the appellant successfully pled anything that would suggest that it had to be specifically provided in the order.
Well, okay, let me try it a different way then. You agree 2012-119 is not applicable?
Correct.
Do you agree Rule 11 is not applicable?
No, I think Rule 11 so I was getting to the second
Okay.
order. The order that was entered on November the 8th of 2019, Your Honor, that was based upon the court's order specifically provides that that fees shall be awarded for successfully defending a Rule 11 motion. Now, it has an alternative. I mean, there was some alternative language about 2012-119, but however, the court specifically provided in its order that they were awarding us fees for successfully defending a Rule 11 motion.
Does the court have authority to do that?
Yes, I think the court has absolute authority to do that under the Rule 11 of the Tennessee Rules of Civil Procedure, pursuant to the language that's specifically provided for in the section itself. It says, if warranted, the court may award to the prevailing party on the motion the reasonable expenses and attorney fees incurred in presenting or opposing the motion. I mean, we were presented with a Rule 11 sanction, and we had no choice. I mean, I certainly did not want that to stand, so we asked the court to dismiss it. We had a hearing on that, and the court heard on that day the request from the appellant to sanction us under Rule 11 and also our request to dismiss the case under Rule 12. The court chose the court did award our fees based upon Rule 11 and or Tennessee, the 20-12-119. So the court did not abuse its discretion in awarding our fees because they did have a basis, which was the Rule 11.
Let me ask you, who were the parties to the motion to enforce the settlement agreement?
The parties were the same as they are here today. So myself, on behalf of Judy Franklin and Renee Steinberg, and then Aubrey Brown, who represented Kimberly Steinberg, were the parties who brought the motion to enforce the mediated settlement agreement against Ida Steinberg.
And you argue that somehow that inured to the benefit of the estate. It seems to me that it inured to the benefit of the parties who settled that matter, as opposed to the estate.
Well, the estate has been opened since 2018, and the estate was not making any progress or moving. I mean, the estate was, part of the settlement agreement was if it was found that that these royalty rights were freely assignable, then the royalty rights were not going to be continued to held in trust. There was a testamentary trust inside the estate. So the only way to get the estate to the next posture or the next place was to file a motion seeking to enforce the very settlement agreement that we worked so hard to reach.
Well, did the court enter an order making a legal decision that the royalty rights were transferable?
Yes.
Or did the court simply enforce the agreement where the parties agreed to how the royalties were to be split?
Oh, well, the court enforced the specific language which provided that upon receiving expert proof or the proof from this designated person that the royalty rights were assignable, then they shall be assigned. That a motion had to be filed to get the Ms. Steinberg to do that. So I contend that it did benefited, inured to the benefit of the estate and its beneficiaries.
What does the attorney fee provision say in the settlement agreement?
It is silent as to that.
So there is no attorney fee provision in the settlement agreement?
There is not anything, no, there is not to my recognition. I don't have it in front of me today, but I don't believe there was.
So the triggering event, if I understand your argument based upon your responses to Judge Armstrong, is the court must have found that these activities inured to the benefit of the estate.
Correct, and there's I do believe that is what the court based it on, based upon.
But the court didn't say anything like that.
Correct. I'm not here to suggest that they did. I just believe that the court has in its power in awarding attorney's fees to determine that our actions did inure to the benefit of the estate. However, there was no specific finding in the order that suggested that.
And did the court, I know I'm working with two different orders here, did the court ever say it was awarding attorney's fees pursuant to Rule 11?
The court stated that the counter motions, in the order granting motion to dismiss and denying counter motion for sanctions, the court in its ordering part of the order said the counter motion for sanctions filed April 17th, 2019 is denied. And then in the second paragraph, it's the motion to dismiss filed April 26, 2019 is granted. And then it reserved this matter for further hearing.
Was there I'm sorry.
Go ahead.
Was there a transcript of all these hearings?
There was.
Okay. Did the court say anything in the transcript that's not contained in the order?
Not as far as I am aware, there was not anything further contained in the court's transcript that's not transcribed herein. However, I guess we came before the court on a motion for sanctions that was filed by the appellant. The only other, then we refer the next order on the issue, the court denies counter motion for sanctions, which the only sanction that the court could have been referring to was the Rule 11 sanction, is denied. Then you look at the Rule 11, you go to the rules and look at Rule 11, and it says that the court may award fees to the prevailing party. We were the prevailing party because we successfully defended the motion. So that is why I believe that the court did not abuse its discretion in awarding our attorney's fees under Rule 11.
Did you successfully defend the motion, or did you successfully point out that they failed to comply procedurally with Rule 11?
I believe that I successfully was able to defend a motion because a motion for sanctions was filed against both myself and Mr. Brown, and we were able to successfully have that motion for sanctions, it was successfully dismissed. So that is
Because they failed to comply with the
because
safe
they
harbor
failed to comply with the
provision.
21-day safe harbor provision.
And let me make sure I understand this, because I understood from what Attorney Vinson argued that maybe the fee award was against the personal representative, but as I read the order, the fee award is simply against the estate. Is that right?
I think there are questions about that. I think the way the order reads, yes, that is how the order reads.
Well, so there can't be any question.
Right, correct.
Okay, all right.
And the other,
Let me ask you one question.
Sure.
When you referenced earlier that it was for the benefit of the estate. That was your argument, that this inured to the benefit of the estate. But essentially, if I'm following what you're saying, you're arguing that the benefit to the estate was actually the ability to further the administration of the estate. Is that correct? Not a financial benefit necessarily to the estate, but just the ability to proceed with the administration.
it is to further proceed with the administration, and then also a personal representative owes a fiduciary duty to not only its beneficiaries. So while it also benefited the further administration of the estate by taking care of and moving the case along to completion, does benefit. I mean, yes, there is a benefit to the beneficiaries, but so there would be both. I mean, both, it did benefit the estate for keeping the administration going, and also it did benefit the beneficiaries by keeping the administration going. We were in a position of complete and utter standstill. So there had to be some movement forward, and but for us bringing the motion, we would not be. We would still be where we were.
Thank you.
Under the agreement, the royalties that are going to be paid, are they going to be paid through the estate or directly to those parties named in the mediated settlement agreement?
They were distributed outside of the estate to the named beneficiaries. I mean, that was the idea, that the state would no longer house them, and then they would be funneled to the proper named individuals instead of the estate.
So not paid through the estate?
Not paid through the estate.
Okay.
Thank you.
Thank you. We will hear from you in rebuttal, Mr. Vincent.
Yes, sir, thank you. Very briefly.
Well, attorney says very briefly, that actually means nothing.
Understood.
Normally.
So I struggled whenever I drafted the brief, both the briefs that we filed in this case, because I felt like that I had to speculate as to what the intention of the orders were and what the grounds of the orders were. I can read rules and I can read cases, but the problem is once I go read the rules and I read the cases, I see things that aren't in the orders that were supposed to be in the orders, if that makes any sense. And the problem that I believe that these orders have at the very core of them is that these motions that were heard and the orders that granted the motions and denied the Rule 11 under the safe harbor were around November-ish of 2019. These orders that are being appealed and we're discussing were not entered until end of July of 2020. And there's nothing, perhaps that has some basis for the reason why there's nothing articulated in them, I don't know. But at the end of the day, the orders are silent on what the trial court's thought process was in granting them.
Was there a reason for the delay in the orders?
I do not know the answer to that question, John. I don't know.
Did the court prepare the orders or did the parties prepare the orders?
I believe the parties prepared the orders. The winning party, as normally happens. But as all your honors know, courts speak through orders, and these orders are deficient in terms of the grounds for attorney's fees. There's been a lot of discussion about, what the settlement agreement itself said and other things, and I understand that in order to try to get to the trial court's reasoning, but we shouldn't have to do that. We should be able to pick up the orders and we should be able to read them and see whether or not, one, they comply with anything related to the settlement agreement, including an attorney's fee provision, which there is none, or a case that was never argued should be very well articulated in the order itself as to how this award inured to the benefit of the estate. I would submit that it can't. It went outside of the estate. That is not inuring to any benefit of the estate. But even if it had, there's a burden shifting analysis that appellees have brought up in their brief that relate to how they initially meet their burden to show that the burden of paying the estate to lawyers that are not representing the estate itself should be paid outside of the normal process. And that never happened. It just didn't. And with regard to Rule 11, it is a procedural denial. That's what it is. The procedural denial is not articulated in Rule 11.02. That having been said, even assuming for the sake of argument that it wasn't a procedural denial, that we had a full-blown hearing on conduct that's described in Rule 11, the judge still has to comply with Lambert and has to comply with Rule 11. Rule 11 states, and there's two words that are being left out of some of the quotes about what Rule 11 says. What it says in 11.031A is that if warranted, the court may award to the prevailing party on the motion the reasonable expenses and attorney's fees incurred in presenting or opposing the motion. If warranted means more. That's in there for a reason. Words mean something. In this case, those words are very well articulated. Their meaning is in the Lambert case. It says that the judge has to comply fully with Rule 11, which includes 11.033 and the Lambert case about whenever you're going to impose these sanctions, which are meant to be punitive, that you have to articulate in the order the basis for the sanctions and the conduct described, which bootstraps back onto 11.02. That's not in the order. It's just not. Oh, last issue. Then I promise I'll be brief. There was a request for attorney's fees made on appeal. There's no basis for that. Very clearly, the judge's orders, trial court orders, were deficient, and that's why we're here. The case should be, those orders should be vacated, the attorney's fees award should be vacated. And any suggestion that this was a frivolous appeal, which is not even in the briefing, but to the extent that that's where anybody was going, it's not a frivolous appeal. This needs to happen in order to make sure that people aren't getting awarded something, especially against a state where people do have fiduciary duties. Attorney's fees that have to be potentially paid individually or outright from the state when there's just no basis for it.
Thank you.
Thank you.
Thank you, counsel. We appreciate your argument. As Judge Clement said several times yesterday, you've given us something to think about. We will take this matter under advisement and attempt to get you an opinion at the earliest time possible. Thank you.
Thank you.
Ms. Angie, you may call the next case, please.
Stavansky Bunton versus